Thank you for coming. I thought your brief was extremely well done. It was helpful.
Thank you, Your Honor. May it please the Court. Your Honor, for some of the reasons we mentioned, we think we have very good reasons why the state is not likely to prevail on the merits, but I'd like to start with standing, which I think distinguishes this case from some of the other cases that have been filed around the country.
Well, let's concentrate on standing. Tell me why you think the Fifth Circuit's wrong in what seem to be fairly marginal circumstances, and they strongly come out without hesitation or doubt to find standing.
Well, Your Honor, we do disagree with the Fifth Circuit's decision. Of course, we also think that that case would be distinguishable. We disagree with the decision because we do think it has to be a particularized impact on the state. In United States v. Texas, the court found that the state itself had injury. It wasn't an injury in its parents' patriotic capacity. And it was basically that the...
Let me stop you. In the state of Washington, I can't speak to Minnesota, but both the University of Washington and Washington State are considered parts of the state government. And they've cited a litany of direct consequences, damages, to them. That's compared to, what, $13.40 in Texas for issuing a driver's license.
Well, Your Honor, in Texas, it was a monetary injury, right? Here, the injuries that the state talks about to its universities in particular are reputational harm, or that students won't come there, that it will undermine their diversity. They don't cite any cases that define a lack of diversity at a university or something like that, even assuming they could prove that as an injury.
I don't think that's their argument. I think they're talking about direct financial harm in their declarations.
I mean, I don't read them that way, Your Honor. I didn't see any sort of calculations of financial harm like there were in Texas. They talked about faculty members that might not be able to teach, although most of those were lawful permanent residents that actually are not affected by the order. They talked about the possibility of some students that might not be able to travel. Most of it was very speculative. I didn't see, the only place that I saw numbers of monetary losses was in their allegations about lost tax revenue. And as we explained in our brief, lots of courts have recognized that sort of generalized grievances like that are not cognizable injuries, and analogizing it to the taxpayer standing context.
If I have a student who's admitted to one of those two universities who's in a country who is now unable to come to the United States, enroll, and pay tuition, is that not a direct financial harm?
Your Honor, we don't think it's a direct financial harm to the state. We think it's, I mean, perhaps given the circumstances, and it would depend on the circumstances, could be a harm to the individual. But
they're benefiting. They're not paying that outrageous tuition. But you know, it's the University of Washington, part of the state of Washington, or Washington State, part of the state of Washington, who are not receiving these dollars from this student who, under the executive order, can't get into the United States.
Well, Your Honor, I mean, first of all, I would point out that I'm not sure that they make those allegations of a specific student, but I would also say that we think that that injury is too far down the chain of causation, that it's an incidental impact. And if Your Honor were to find standing in that circumstance, it's hard to imagine a federal law or a federal action that wouldn't in some way down the line have effect on states, which would essentially allow states to sue to challenge any federal law. If they could point to a way in which some individual was affected by the law because it applied to them, and then that the effect on that individual had some effect on the state. And we think that that's too expansive of a definition of standing.
Well, the odd couple of the Fifth Circuit, in their opinion, in United States versus Texas, that seems to me to, basically follow the lines of what you just said is improper.
Well, Your Honor, as I said, we respectfully disagree with the Fifth Circuit's decision, and note, of course, as Your Honor knows, that you're not bound by that decision. Plaintiffs haven't cited anything in the Ninth Circuit that relies on that sort of injury. As we explained in the briefs, some of the cases they cited, I believe the one school case that they cite involved a bank that had terminated its loan guarantee program with the school. So that was a more direct effect on the school. Whereas here, the government is not regulating in any way the school. The government's interactions are with individuals, and there are perhaps down the line consequences on the state, although we think many of those, and if not all of them, are speculative.
Well, let me move you off of standing, if you would. given the breadth of authority of the executive in the area of immigration, do you acknowledge any limitation on his or her power?
Your Honor, I don't think Your Honor needs to answer that question to decide on this case.
No, but it seemed like a good question.
Given, I don't think it would be wise to sort of opine on what the extent of the executive's power is. I mean, I think here we have specific circumstances where the President has issued this executive order. It was pursuant to authority that Congress gave him in Section 212F of the INA that specifically allows him to suspend the entry of certain aliens or a class of aliens when he finds that it would be detrimental to the interests of the United States to allow them in. So here we have the President acting pursuant to power that Congress gave him, which means under the Youngstown still seizure cases, he's acting at the apex of his power. And the executive order, as Your Honor mentioned, is tied, the countries that it applies to, is tied to countries that Congress previously, for two of them, explicitly designated as countries of concern, and that Congress designated authority to the President to federal agencies to designate other countries, and under the prior administration, the remaining 5 countries were designated as areas of concern. And so we think in the context of, certainly in the context of this case, the President is acting well within the authority that Congress has given him. And Your Honor need not opine on what he may or may not be able to do beyond that. Your Honor, with respect to the plaintiff's argument that the President's authority is somehow limited by Section 1152A1A of the INA, as we explained in our briefing, we don't read that as a limitation on the President's expansive power under 212F. As we noted in our briefs, there have been other presidents that have exercised the power in 212F in ways that distinguish between nationalities, as the President has done here. We also mentioned that these distinctions between nationalities were made explicitly by Congress in 8 U.S.C. 1187, and that's what the President has tied the executive order to here. And so we don't understand 1152A as imposing a limitation on the President's power. If it did, as we pointed out in our brief, you can imagine a situation, that provision would prevent the President from suspending the entry of aliens from countries that the United States has to be at war with. And we don't think that that's a fair reading of the statute. So we think that 212F applies in situations where the President has made the determination that the entry of certain aliens would be detrimental to the United States. In situations where when that determination has not been made, then the other provision in 1152 applies to prevent these discrimination, to bar certain types of discrimination in the issuance of immigrant visas.
I'd like to move you along to equal protection,
sure,
if we can. You strongly urge that strict scrutiny doesn't apply. Can it ever apply in the immigration context in the government's view?
Your Honor, again, I hesitate to opine on whether it can ever apply as opposed to whether it applies under the circumstances of this case. The courts have made clear that distinctions based on nationality, which is what this executive order does, in the immigration context are completely valid and legitimate and do not violate the Constitution. And so in the context of this case, there's no equal protection violation. With respect to the argument of religious discrimination, again, it's a little bit confusing whether exactly what the state's religious discrimination claim is. We understand it to be limited to Section 5 of the executive order, which is about refugees. And in that context, for reasons Your Honor had mentioned, we think the claim is unripe. But it also, that provision doesn't discriminate against religion. Well, no, but it may not discriminate, but it favors one over another. It doesn't, Your Honor. It sets up a system where, and again, it doesn't even set up a system. It says 120 days from now, once the suspension of the refugee program is back on track, that the executive branch, the Secretaries of Homeland Security and Secretaries of State, are to are to make changes to the extent permitted by law to the prioritize refugee claims based on religious-based persecution where the religion is a minority religion in that individual's country of nationality. Now, Your Honor, that program doesn't just apply, or that provision doesn't just apply to the 7 countries that are designated in Section 3 of the order. It applies to all countries. So you can imagine that while it might be true that the 7 countries are majority Muslim, there are other countries where Islam would not be the majority religion. And in those contexts, the minority religion might be Islam. So,
well, but under the establishment cases, I think you're arguing against your own position, aren't you? What you're saying is in any particular country, we're going to reward someone for belonging to a particular faith or practicing a particular faith.
Well, Your Honor, I don't think we're saying that. I mean, the government has long prioritized or permitted asylum claims or other types of claims in the immigration context based on religious persecution. So the government's not doing anything different than what it's already done. It's not about the particular religion. It's essentially accommodating religion, which the government has always done. But as Your Honor, as we said before, this is something that the President has directed executive agencies to look into this matter going forward. And so certainly until 120 days passes, but we think even beyond that, because until it's actually implemented, we don't know what it's going to look like, that there's no establishment cause problem.
All right, I think I understand your argument. Let's talk about Section 3. So I'm going to do the same thing, trying to leave you some time to just talk as opposed to be interrupted. The rationale for Section 3 is invoking 9/11. And my question to you is, have there been terrorist attacks in the United States by refugees or other immigrants from the 7 countries listed since 9/11?
Your Honor, I don't know the specific details of attacks or planned attacks. I think I will point out first of all that the rationale for the order was not only 9/11. It was to protect the United States from the potential for terrorism. I will also note that the 7 countries that are listed in the executive order are the same 7 countries that were already subject to other restrictions in obtaining visas that Congress put in place, both by naming countries, Syria and Iraq, and that the prior administration put in place by designating them as places where terrorism is likely to occur, or the specific factors, or whether the president's presence in a particular country increases the likelihood that an alien is a credible threat to U.S. security or an area that is a safe haven for terrorists.
Well, let me walk you back then. You're from the Department of Justice, if I understand correctly.
Yes.
So you're aware of law enforcement. How many arrests have there been of foreign nationals for those 7 countries since 9/11?
Your Honor, I don't have that information. I'm from the Civil Division, if that helps get me off the hook any.
Well, let me tell you, the answer to that is none, as best I can tell. So, I mean, you know, you're here arguing on behalf of someone that says we have to protect the United States from these individuals coming from these countries, and there's no support for that.
Your Honor, I think the point is that because this is a question of foreign affairs, because this is an area where Congress has delegated authority to the President to make these determinations, it's the President that gets to make the determinations, and the court doesn't have authority to look behind those determinations. They're essentially like determinations that are committed to agency discretion. Well, and we do think that, despite plaintiffs' claim that Kleindienst v. Manziel is directly on point, and that if the 4 corners of the executive order offer a facially legitimate and bona fide reason for it, which they do here, that the court can't look behind that.
Well, Counsel, I understand that from your papers, and you very forcefully presented that argument. But I'm also asked to look and determine if the executive order is rationally based. And rationally based to me implies that to some extent I have to find it grounded in facts as opposed to fiction.
Well, Your Honor, we actually don't think you are supposed to look at whether it's rationally based. We think that the standard is, again, facially legitimate. And that there are some cases that say the court would have to find it wholly irrational. And again, Your Honor, I would point to the fact that Congress itself has specifically designated two of these countries as areas of concern with respect to terrorism, and the Obama administration, the executive branch, designated the remaining 5. And so it's not that this executive order is in that regard saying anything new about these being countries of concern as it regards to terrorism.
Well, let's go back to something you were starting to get around to when I interrupted you. You were going to argue Katzenbach. Isn't that just classic dicta?
Your Honor, I think to the extent you're talking about that states don't have due process
I'm talking about
rights.
the language you quote in your brief.
Well, we also, I think, cited that case for the idea that states don't have parens patriae standing. But for the idea that states don't have due process rights, we cite other cases in our brief. I think that's a well-established. The Fifth Amendment applies to persons, and cases establish that the state is not a person in that regard, and so the state doesn't have due process rights to assert.
Well, then how do I reconcile that with Massachusetts versus EPA?
Your Honor, in Massachusetts EPA, which was a standing case, right? The facts were very specific. There you had two factors that the court found relevant. One, you had an actual injury to the territorial sovereignty of Massachusetts. The court talked about how global warming actually affected the territory of Massachusetts, its coastline area that was owned by the state. And the second factor was that Congress had explicitly given states and other parties a procedural right when someone petitioned the EPA to look into global warming and the EPA denied that petition, then Congress created a procedural mechanism for that person to challenge that decision. So the court said in an area where the state has an injury in fact, it's an injury to its territorial sovereignty, and this explicit procedural right, that they're standing. And neither one of those circumstances are present here. Washington, of course, doesn't allege any injury to its territorial sovereignty. It doesn't, its other alleged injuries are sort of incidental.
But explain to me what you mean by the term territorial sovereignty.
Or it's injury to its territory. So it's pollution of its rivers, for example, pollution of its coastline, pollution of its land.
So the federal government could do whatever it wanted to people who live here, and as long as the land's not damaged, there's no harm? Or there's no cause of action?
Well, Your Honor, I wouldn't make a statement that broad. I think that the statement I would make here is that when the federal government regulates individuals and there are sort of speculative downstream effects that might affect the state in terms of lost revenue and stuff like that, cases have said no, that's not sufficient, that it's not sufficiently direct, as it was in Massachusetts.
All right. Before I run out of all your time also, what limits does 1152A1A place on the executive?
Your Honor, we think so. In terms of when, as I was trying to explain before, in terms of when the President has made a determination under Section 212F of the INA that entry of certain aliens should be suspended because it would be detrimental to the United States otherwise, we think that trumps the 1152A.
Well, so let's concentrate on that. You argue this in your brief, that the executive can classify aliens by origin of birth or nationality. And then there is a statute that says the classic anti-discrimination language. How do I reconcile those two concepts?
Your Honor, so we think that the 1152A only applies when the President has not made that designation. And I will, to sort of play this out a little more.
You stop there. Tell me what the authority is for that argument. You make it in your briefing, and you don't give me any authority for it there. You just sort of make the statement that, yes, that's our position. Help me understand where it comes from.
That I think the first principle would be that the court is supposed to attempt to reconcile competing provisions of a statute. I think there's also, Your Honor, a constitutional avoidance point. Here the President is acting in an area of his Article II powers in foreign affairs, and if the court were to find some sort of conflict between the two, the court might run up against the constitutional question of whether the President had authority to make distinctions based on nationality.
Or the executive is running up against the law that Congress has passed.
Well, Your Honor, to the extent that you're concerned about that, I would just note that Congress itself, in the INA, makes those very same distinctions based on nationality in the provision that the President is relying on here in 8 U.S.C. 1187, where it says that different rules in terms of applying for visas apply to, and it names two countries, Iraq and Syria, and then allows the President to designate others. We think that a reading that says that 1152 applies no matter what would trump that provision, or would suggest that that provision is invalid.
I don't get a lot of chance to do a statutory interpretation, but let's concentrate on that for a moment. As I understand it, 1152A was promulgated after 1182F. Do you agree with that?
Yes, Your Honor.
And didn't Congress then had to, by statutory construction, Congress had to be aware of 1182F?
Yes, Your Honor, that's right.
And in that particular provision, it makes a number of exceptions, but it does not accept to 52.
Because we don't think Congress thought it applied. Again, this is the 1152A is in a narrower section of the statute that talks about creating a uniform quota system for immigrant visas, for which people are going to be allowed to come in this country. And we just think that that's a narrower section of the statute, and that the President's broader authority, again, Your Honor, I hesitate to repeat this, but I think it's a good example. I mean, Your Honor, if this provision of 1158-2 trumped 212F, then the President would essentially be prohibited from restricting the entry of aliens to a country at which the United States was at war. And we just don't think that Congress could have meant that.
You've shaken those bones about as much as you can get out of them. Why shouldn't the Court assume that Congress did not want to accept 1182F from the operation of 1151? I mean, Justice Scalia has not been with us for a year, but it seems to be what you're running to now is, all I got to do is look at the legislative history, and that must have been what they meant.
Well, I don't think Your Honor needs to look at the legislative history. I think you can look at the text and the structure of the statute, that this broader power authorizing the President to suspend the entry of any aliens or any class of aliens supersedes this other provision that otherwise would apply in the absence of that. I would also note, Your Honor, that we also make additional arguments in our brief that about the procedural exemption to 1152A and its narrowness as well. But we think 212F trumps that provision.
All right, you've got about 6 minutes left, so I won't interrupt you either for a bit here.
Okay, Your Honor, thank you. I would just make a few more points. I think I covered largely what I wanted to cover, but with respect to the remaining two preliminary injunction factors, I would just say that the state, we don't think they've established standing and injury, but certainly even if Your Honor disagrees, they haven't shown irreparable harm. As this process has sort of shown, the executive order sets up a case-by-case, or sets up a system where there can be case-by-case waivers of specific exemptions. And so the idea that a state can come in and sort of sue on behalf of all of its citizens without really sort of playing out specific circumstances where it's been applied unlawfully, we think that's not the proper avenue for a TRO. Again, that certainly perhaps some of these individuals could bring their own case, and we'd have to look at the facts of those cases. But as for this facial challenge, for Your Honor to enjoin this restraining order, or frankly even parts of it, even provisions of it, we think that's a facial challenge, and Your Honor can't do that in light of the fact that it is lawful in some of its applications. And then we would just point to the balance of the equities, Your Honor, and note again that in this regard the President